Hello, I am Pınar Özcan, working as a research assistant at Istanbul University Faculty of Law, Department of Criminal Procedure Law. I am the session presenter of our Law on the Bosphorus Summer School today. I would like to thank to those who were with us by watching our program from the beginning, to my colleagues who worked diligently in the organization of the program, to our professor who enlightened us with their presentations, and to Professor Adem Sözer, who made all this happen and stands by the rights of women all over the world, especially women in Turkey. Today, we are together with two very valuable professors who will make presentations to us. Professor Burcu Dönmez is Professor of Criminal and Criminal Procedure Law and currently works in Yaşar University. She has many published works. One of her areas is the prevention of violence against women. She has articles on the crime of torment against women. Today, she will give a lecture on Law number 6284 on the protection of the family and the prevention of violence against women and the crime of torment. Floor is yours, Professor.
Thank you, Pınar. Before I start my speech, I want to thank you all, and especially for Adem Sözer for inviting me here, and I'm honored to be part of it. Is my voice okay?
Yes, everything is perfect.
Okay. Today, I would like to give information about the regulations of Turkish law related to the crime of torment against women. But before I assess crime of torture against women, I would like to indicate the effects of Istanbul Convention and 6284 numbered code provisions on inquiry and prosecution stages. As all you know, in 20 March 2021, within the publishing of 3718 numbered presidential decree on official gazette, Istanbul Convention, in other means, Convention of Europe on preventing and combating violence against women and domestic violence, has been terminated. Although the discussions in doctrine and practice about the procedure of termination prevails, I want to begin my speech with the related provisions of Istanbul Convention, which still constitutes the source of 6284 numbered code. Especially, I will emphasize the issues of the convention related to the torment against women. Okay. Three topics will be spoken today. Firstly, Istanbul Convention. Secondly, 6284 number, protection of family and prevention violence against women. And Turkish Criminal Code, Article 96, crime of torment. First of all, we have to determine that because of 6284 numbered code is still giving reference to Istanbul Convention as a source, the convention norms are still valid in Turkey. However, it has been terminated by the president. This is my opinion. Then the convention provisions are still in effect until it is cancelled from court. Therefore, before I give information about the crime, I will try to remind you the related articles of the convention. As you see, the Article 1, purposes of the convention is prescribed. In the first article of convention, the purposes of the convention are described, but the purposes which is related to our issue laid down, especially in the paragraphs A, C, and E. But also the other purposes, of course, are essential for protection, for protecting women. I would like to emphasize the related ones. Firstly, protect women against all forms of violence and prevent, prosecute, and eliminate violence against women, and eliminate violence against women and domestic violence. C, design a comprehensive framework, policies, and measures for the protection and assistance to all victims of violence against women and domestic violence. And E, provide support and assistance to organizations and law enforcement agencies to effectively cooperate in order to adopt an integrated approach to eliminating violence against women and domestic violence. And in the second paragraph of the same article, it says, in order to ensure effective implementation of these provisions by the parties, the Convention establishes a specific monitoring system mechanism. In the second article, the scope of the convention has been arranged. And according to the article, this convention shall apply to all forms of violence against women, including domestic violence, which affects women disproportionately. Parties are encouraged to apply the convention to all victims of domestic violence. Parties shall pay particular attention to women victims of gender-based violence in implementing the provisions of the convention. The violence against women and domestic violence conceptions are also defined in Convention in Article 3. According to the definitions, violence against women is understood as a violation of human rights and a form of discrimination against women, and shall mean all acts of gender-based violence that result in or are likely to result in physical, sexual, psychological, or economic harm or suffering to women, including threats of such acts, coercion, or arbitrary deprivation of liberty, whether occurring in public or private life. And domestic violence shall mean all acts of physical, sexual, psychological, or economic violence that occur within the family or domestic unit or between former or current spouses or partners, whether or not the perpetrator shares or has shared the same residence with the victim. In Article 4, parties shall take the necessary legislative and other measures to promote and protect the right for everyone, particularly women, to live free from violence in both the public and the private sphere. In Article 5, Convention prescribes the state obligations such as parties shall refrain from engaging in any act of violence against women and ensure the state authorities, officials, agents, institutions, and other actors acting on behalf of the state act in conformity with this obligation. Parties shall take the necessary legislative and other measures to exercise due diligence to prevent, investigate, punish, and provide reparation for acts of violence covered by the scope of this convention that are perpetrated by non-state actors. Convention is also arranged many other obligations for the parties, such as awareness-raising activities, education programs, training of professionals, preventing intervention and treatment programs, participation of the private sector and the media, protection and support activities, general support services, assistance in individual collective complaints, specialist support services, shelters, phone helplines, support for victims of sexual violence, protection and support for child witnesses, reporting by professionals. Convention is also bringing obligation on parties for regulating civil and criminal provisions. Because our issues depending on criminal law, I would like to summarize criminal obligations related to the convention. Parties shall take necessary legislative and other measures to ensure these following acts as a crime. What are they? First, physical violence against another person, coercion or threats against a person's psychological integrity, stalking, sexual violence, forced marriage, female genital mutilation, forced abortion, forced sterilization, and sexual harassment. Unacceptable justifications for crimes, including crimes committed in the name of so-called honor, has to be forbidden. The offenses established in accordance with the convention shall apply irrespective of the nature of the relationship between the victim and the perpetrator. Istanbul Convention leaded to prescribe 6284 number code and 20 March 2012 6284 number code, protection of family and women against violence, has come into effect in Turkey. Within this code, 4320 number protection of family code terminated. Now I'm going to give you information about Law number 6284, Law to Protect Family and Prevent Violence Against Women, related provisions with our issue, and also parallel arrangements with Istanbul Convention. 6284 numbered code covers the measures for protection and prevention of violence against women and children and family members, and also protects and supports and take the necessary legislative or other measures to ensure that the intentional conduct of repeatedly engaging in threatening conduct directed at another person, causing her or him to fear for or her or his safety, is described violence different from X code, and this definition includes economic, psychological, sexual types of violence nearby physical violence. I can signify evidently that within the reference in the second article, most of the fundamental rules and regulations of this code, which depend on Istanbul Convention, secure the guarantees of Istanbul Convention. The code also covers the persons who are not married. It is also significant because during 4320 numbered code, the X code, the issue was controversial and Supreme Court made many interpretations in dispute. Another important thing is the expansion of the definition, who performs violence. In the code, the ones who perform violence has been described as the ones who performs manners and conducts defined violence in the code, and the ones who have risked to perform violence. Preventing and supporting measures and compulsory detainment are also considerable regulations of this code. Within this code, it is possible to initiate prosecution and to take measures by the judge and the governor without requiring any evidence or document following the reporting by the victim of the offense. We can separate measures as protective cautionary measures and preventing cautionary measures. Protective measures can be both given by civil authorities and judge, but preventing measures can be decided only by judge. According to the 6284 numbered code, in Article 3, the protective cautionary decisions to be taken by civilian authority are described. Now, you see the article and the measures prescribed by the law. Especially, I would like to emphasize 5 cautionary protective decisions. These are to provide an appropriate shelter to a person, and if necessary to the person's children in the vicinity or in some other location, to provide financial aid to the person without prejudice to other assistances provided within the scope of other laws, to provide psychological, professional, legal, and social guidance and counseling services, to provide a temporary protection upon a request of a relevant person or ex officio if there is a life-threatening danger for the person, if deemed necessary, 4 months of day care, maximum 2 months for those who have a job, is provided to children of the protected person to support the person's integration into work life. The amount which cannot exceed the half of the net minimum wage paid to those older than 16 years of age with the condition of documenting is covered from the ministry's related budget. In cases where delay is considered to be risky, the measures as contained in the paragraph 1, clauses A and G, shall be taken by related law enforcement chiefs as well. A law enforcement chief shall present the report to the administrative chief for approval not later than the first workday after the decision is taken. The measures which are not approved by the administrative chief within 48 hours shall be per se abolished. Protective cautionary decisions to be taken by the judge are described in Article 4. And again, one of them or several of them or similar measures appropriate can be decided by the judge in this within the scope of this law. What are they? To change the workplace, to decide a house different from the shared one if the person is married, to put an annotation to the title deed as a family house if the conditions are applicable as contained with the Turkish Civil Code, and upon the request of the protected person, to change the identification and other related information and documents based on the informed consent of the relevant person as per the provisions of the witness protection law. If it is determined that there is a life-threatening danger for the protected person and the measures to prevent this danger are inadequate. Article 5 brings preventing closure decisions. They can be taken only by judge. Again, one or several of them can be adapted to the appropriate circumstances. They are prescribed as not to exhibit an attitude and behaviors, including the trace of violence, insult, and humiliation against the victim of violence. In practice, this is a little bit hard to apply because you are given decision, but you cannot check it afterwards. To move from the shared dwelling or the vicinity immediately and to allocate the shared dwelling to the protected person, not to approach to the protected persons and their residences, schools, and workplaces. If there's a previous decision to allow having a personal connection, to have a personal connection with the children together with a company, and to restrict the personal connection or to revoke it completely, not to approach the friends or relatives and children of the protected person, even though they haven't been subject to the violence, without prejudice to the decisions that allows personal connection with children, not to damage the personal belongings and household goods of the protected person, not to cause distress to the protected person by means of communication instruments or alternative channels, to hand over the officially permitted and authorized weapons to the law enforcement officials, to hand over the weapon to the employing institution, even if the person is in professional or public service that requires carrying a weapon, not to use alcohol, drugs, or stimulants in places where the protected people are present, or not to approach to the protected people and whereabouts while under the influence of these substances, and to ensure to have a medical examination and treatment, including inpatient treatment in case of addiction. To apply the health center for examination or treatment and to ensure having a treatment. In cases where delay is considered to be risky, the measures as contained in the clauses A, B, C, D of the first paragraph shall be taken by the relevant law enforcement chiefs as well. The law enforcement chief shall present the report to the judge for approval no later than the first workday, after the decision is taken, of course. The measures which are not approved within the 24 hours by the judge shall be per se abolished. When the measures identified within this law, the judge is authorized to take a decision on protective and preventive measures as contained within the Child Protection Law 5395 numbered code on the issues of guardianship, custody, alimony, personal connection, as per the provisions of Turkish Civil Code. If the perpetrator of the violence is the person who at the same time the provider or the contributor of the family's livelihood, the judge may decide on a temporary alimony by taking into consideration of living standards of the victim, even without request, provided that no decision on maintenance had been rendered priorly as per the provisions of law number 4721, Civil Code. In practice, having more than one protection measure complaints of abuse or threat against perpetrator in different times are assessed as torment against women by the prosecution and counter-prepare indictment on torment. In other meanings, we can assume that these measures and complaints are forming the indictment and changing the type of the offense. Another essential point is reporting. According to the Article 7, if there has been violence or there is a risk of it, everybody can report this situation to the official authorities and organs. The public officials who receive the report are obliged to fulfill their duties without any delay and inform the authorities for the other measures needed to be taken. The cautionary decision is taken either upon a request of the relevant person or law enforcement officer or public prosecutor. The cautionary decision may be requested from the judge, administrative chief or law enforcement unit, whichever is in the nearest and the easiest location. The cautionary decision is taken for the 6 months period at most initially. However, it is determined that there is a continued risk of violence. The measure shall be extended, modified, abolished, or kept ex officio, or upon a request of the protected person or the officials of ministry or law enforcement agencies. No evidence or report proving the violence is required in order to take cautionary decision. The preventing cautionary decision is taken without delay. This decision cannot be delayed as to endanger the realization of the aims of the law. The cautionary decision is pronounced or notified to the protected person and perpetrator of violence. Regarding to the refusal of the request for a cautionary decision, only the protected person is notified. In cases where the delay is considered to be risky, the perpetrator of violence is immediately notified with an official report on the cautionary decision taken by the related law enforcement unit. The legal warning stating that the person is subject to preventive imprisonment in the case of acting contrary to the cautionary decision is issued when the cautionary decision is pronounced and notified. If deemed necessary, in addition to the cautionary decision, the identification information of the protected person or other family members, or the information to reveal their identification, their addresses, and the other information important for the efficiency of protection shall be kept confidential within recourse upon a request or ex officio. A different address is identified for the notification to be sent. The person who illegally gives, reveals, and discloses this information to somebody else is subject to the related provision of Turkish Criminal Code. If requested, the delivery of personal belongings and documents to the related relevant persons is ensured through law enforcement. The decisions taken as per the provision of the law may be appealed to the family court by relevant persons within 2 weeks after the notification is received. The authority for complaints shall make the decision within a week. The decisions taken by the authority for complaints are the final decisions. The related province and district directorates of the ministry, and depending on the nature of the decision, the public prosecutor and law enforcement officer are notified of the cautionary decisions taken as per the provision of this law through the fastest channels. The authority to which applied for the cautionary decision immediately shall inform the related province and district directorates of the ministry about the applications made to the related authorities and the decisions of acceptance or refusal of the applications within the scope of this law. In case of that, the perpetrator of violence for whom a cautionary decision is taken as per the provisions of this law acts contrary to the requirement of this decision, he shall be subject to the preventive imprisonment from 3 to 10 days by judicial decision, depending on the nature and severity of the violent measure, even if the act constitutes another crime. In each recurring action, contrary to the requirements of the cautionary decision, the period of the preventing imprisonment shall be from 15 to 30 days, but the period of the preventive imprisonment cannot be more than 6 months. The decisions regarding to the preventing imprisonment shall be implemented by the public prosecutor. The related province and district directories are notified of these decisions. Now we come to third topic. This is Turkish Criminal Code regulations, crime of torment, and we are going to compare it with crime of torture. As you know, in Turkish Criminal Code, crime of torment, maltreatment and torture are described as different crimes. At this point, I would like to give you information about crime of torment to women and its comparison with the crime of torture. Crime of torment is arranged in Article 96, Turkish Criminal Code. The victim of the crime can be anyone, but in the second paragraph of the article, committing the crime against pregnant woman or towards spouse prescribed as aggravated torment. Let's check the article. Article 96, you see, any person who performs an act which results in the torment of another person shall be sentenced to a penalty of imprisonment for a term of 2 to 5 years. An aggravated form in second paragraph, where the acts falling under the above paragraph are committed against a child, a person who is physically or mentally incapable of defending himself, or a pregnant woman, or a direct descendant, adopted parent or spouse, a penalty of imprisonment for a term of 3 to 8 years shall be imposed. The torment is understood as a violation of human honor and acts which results in severe mental and physical pain or suffering. It causes serious mental or physical suffering or injury, or constitutes a serious attack on human dignity. In fact, these actions are already the actions of crimes of intentional injury, insult, threat, and sexual harassment. But the difference of torment lays on time. They are not occurring suddenly. They are systematic and repeating actions. The most common characteristics of this crime, like crime of torture, is the demonstrating physical, psychological effects on person. Non-continuation of the effects on person causes to apply more serious sanctions to it, different than the other crimes. In the X code, there is no provision similar to this code, this article. Now, within the Article 96, civil people who torture someone are facing with serious sanctions. The elements that distinguish torment from torture are the absence of the requirement that the treatment be inflicted for a specific purpose and lack of official position. Now, let's look at protected legal issue. According to the Turkish Constitution, Article 17, no one shall be subjected to torture or maltreatment. No one shall be subjected to penalties or treatment incompatible with human dignity. This great provision of torture and maltreatment in Constitution form itself as crimes of torment and torture in Turkish criminal law. The provisions protect corporal integrity, corporal and spiritual existence, healthcare, honor, human dignity of individuals. Let's check the elements of crime. Firstly, actus reus. As you know, the actus reus includes all the elements in the definition of the crime except the accused mental element. It is not merely act, it may comprise conduct and its attendant circumstances or results. First, I will give you information about X circumstances, result, and causality. We have no chance to analyze what is torment only by examining legal description. According to the legal ground of the article, torment acts are described as systematic acts, which violate human honor by suffering mental and physical pain. But of course, it would be better if we write and describe these characteristics of the crime in the provision. So we have to assess acts of torment here by looking at the crime of torture. The acts of torment, except the alternative acts of impressing the ability of understanding and willpower of torture, are defined same as torture in the legal ground. In other words, we can say that lawmaker has been prescribed the actus reus of this crime similar to the torture. Therefore, the acts of torment shall be accepted as all certain acts which violate the victim's honor and corporal and spiritual existence. The acts which cause torment to any other person are forbidden by the provision. The kinds and forms of the acts which result torment are not described in the article. So on, we can assume that crime can be committed by any behavior which results torment. We call these actions in the Turkish doctrine as free-moving actions. In this context, any acts which cause torment can be described as appropriate action. Acts of injury, insult, threat, sexual harassment can be given as examples. The provision doesn't cover acts of omissions, so the actus reus requires proof of an act. According to the legal ground of the article, acts which result with torment must be systematic and must continue in time. Spontaneous and sudden acts are not accepted as torment. Continuity is important here. The separation between intentional wounding and torment crimes specifically based on here. Systematic activity means any structured activity that involves an element of planning, method, continuity, and or persistence. Contrary to the opinion of international human rights and international criminal law conceptions, there is no need to commit the crime under the plan or policy of civil or public persons. Otherwise, it will require always organizations. The characteristics of systematically of the acts differs this offense from intentional injury, threat, insult offenses. If the acts happen systematically and continuously within planning, therefore it constitutes torment, but if they happen suddenly, therefore we prepare indictments based on other offenses. And secondly, I will give you information about the offender of the crime. Anyone can be the offender of the crime of torment. If you follow the legal ground descriptions, the difference between torture and torment lays on the offender's position. If the acts played by a civil offender, then it will be accepted as torment. But if the offender has an official position and has a purpose for obtaining information or confession, the type of the offense will be changed and become torture. But of course, we have to emphasize here the position of the offender is important only for duty actions. If the offense officer commits this action beyond his job, for example, at home or in civil life, etc., therefore it should be accepted as torment as well. Thirdly, victim. There is no special requirement for being victim for torment, but if the victim is child or person who is physically or mentally incapable of defending himself, or a pregnant woman, or a direct descendant, adopted parent or spouse, penalty of the imprisonment increases. As you see, the crime covers everyone, not only women. Maybe lawmaker can make a new amendment on victim part and can add to the woman as an aggravated form. For subject, the subject of the crime is physical integrity, corporal and spiritual existence, and personal dignity and honor of the individual who faced torment is a harm crime. And the last one, the aggravated forms of the crime. This is important. If the acts of the offense has committed to a child, a person who is physically or mentally incapable of defending himself or herself, or a pregnant woman, or a direct descendant, adopted parent or spouse, a penalty of imprisonment increases. The aggravated forms are grounded from the position and roles of the victim. The position of the victim, who is physically and mentally incapable of defending himself or herself, must be detected by the expert report. If the crime committed to a pregnant woman, the stage of the pregnancy would not be important. The important thing is the knowledge of the perpetrator related to the pregnancy. If the perpetrator has no knowledge about it, therefore intent will not cover the aggravated form of the crime. But if the appearance of the woman shows the pregnancy clearly, perpetrator cannot rescue from the aggravated form by claiming no information. For the position of being supposed is determined by the inspection of public family tables. The key issue in here is the date of the act. There must be valid marriage between them according to the Turkish Civil Code regulations. As you see, the provision is insufficient to protect women. For example, unmarried person is out of this aggravated form. Because of the death of the victim after torment has not been described as an aggravated form of the crime, therefore we are adopting Turkish Criminal Codes Article 23 and 87 together and sentencing the perpetrator from aggravated injury. But first we are inspecting his mens rea. If it is intent, therefore we are sentencing him from aggravated intentional killing. If it is recklessness, we are adopting Article 87, fourth paragraph. And now I'm going to give you information about mens rea, mental element. The mens rea of crime is intention. The purpose of the perpetrator isn't important here. Direct intent is sufficient to commit the crime. The perpetrator has to know what he is doing and wish to bring out the consequences of it. According to the article 2nd paragraph of Turkish Criminal Code 26, no penalty shall be imposed in respect of any act committed as a result of declared consent of another person, and provided that such person has the full authority to give consent. But the acts of torment are not in this excused reason because they violate human honor. So far, the individuals have no power of disposition on it. The other excused reasons for this offense are not suitable either in concrete cases. Special forms of crime. Firstly, I will give you information about criminal attempt. But before I give you information about attempt, I would like to give you information about articles related to the issue. The first article is 35 and second one is 36, which regulates voluntary abandonment. 35 prescribes any person who begins to directly act with an appreciate means and with the intention of committing an offense, but has been unable to complete such offense due to the circumstances beyond his control, shall be culpable for the attempt. And 36, voluntary abandonment. An offender who voluntarily abandons the performance of the acts of committing an offense or who prevents the completion of an offense or its consequence shall not be subject to a penalty for the criminal attempt. However, where the completed part of an action constitutes an offense, he shall be subject to a penalty for the completed part of the act. Now, there are two conceptions in Turkish doctrine related to this crime in criminal attempt. The first one accepts any person who begins directly to torment but has been unable to complete the offense due to the circumstances beyond his control, criminal attempt to torment offense will be applied. If the offender voluntarily abandons his performance of his acts, he shall be subject to a penalty for the completed part of his acts if those acts are considered as a part of any other crime. So far, Article 36 shall be applied. According to the 36, according to the second conception for the occurrence of the offense, systematical acts has to be required in time. In the condition for the completing the offense, if the actions do not repeat or occur systematically, therefore we have to apply other offenses due to the position. For example, if the perpetrator captured during damping cigarette or searing hot iron on the body, the other offenses shall be assessed. Therefore, we have to apply criminal attempt to intentional injury instead of criminal attempt to torment. But of course, if those actions have repeated or committed beforehand, therefore the condition for completion of torment crime will be satisfied by systematical actions, and we shall apply the penalty of completed torment offense. According to my opinion, second conception is more appropriate to apply. Secondly, participation. There is no special feature of the offense related to the participation. General rules shall be applied. Any person who jointly performs an act prescribed by law to the victim simultaneously or following each other, and if they shall be assessed as the conditions of being systematical occurrence, therefore all participants shall be accepted as the joint perpetrator of the crime. A person who incites another to commit an offense shall be instigator, and a person who encourages the commission of an offense or reinforces the decision to commit an offense or premises that he will assist after the commission of an act shall be assistant of the crime. If the crime commits under the purveyance of a public professor jointly with civil persons, therefore for the perpetrators who are public officers, crime changes its name and becomes torture. And for the perpetrators who has no special duty, it will be accepted as torment. If the actions carry only by civil persons under the purveyance of public officers, then it will be accepted negligent to torture for public officers and torment for civil persons. Doctrine also alleged that the offense can be accepted as negligent to torment and misuse of public duty crimes for officers, but crime of torture can be committed negligently. So far, in those cases, we have to accept negligent to torture for public officers. Public officers are under obligation of preventing torture, so they become direct offender of negligent to torture by their omissions. We are not applying dependency rule, Article 40 here. Public officer's culpability is determined according to his own wrongfulness, not to conduct of civilians. Aggregation of offense. I'm finishing my speech. These are the last parts. Generally, the most controversial issue of the crime shows itself here, especially the relation between torment and intentional injury is important. In those cases, we are using conceptual aggregation principles, Article 44. The perpetrator shall only be sentenced for the offense with the heaviest penalty. But this practice is criticized by the writers for decreasing the benefit of the torment crime. According to the legal ground of the article, the speciality of the crime of torment, which has continuity in time course, like torture, shows itself by ravages on human psychology and mental health care. Because of those effects last through the life and long-term on victims, it is required to be sentenced seriously. However, by applying the provision of conceptual aggregation in practice, we are facing with opposite results. It is becoming more important, especially for the intentional injuries, if we assess acts individually separate from others. Therefore, we can apply Article 43. Paragraph 3 and have chance to apply penalty for each action. But if we accept the actions as the part of the crime of torment, therefore we have to apply only one penalty for all actions. And this is resulting in less penalty than the other. In these cases, Supreme Court applies the provision of conceptual aggregation, Article 44, and assesses the case as torment. But if it gathers with sexual offenses, therefore Supreme Court accepts both crimes separately and applies penalty from all crimes. Moreover, the penalty of aggravated injury on account of its consequences is higher than the penalty of torment. So then we have to apply Article 81, 82, 83, 85 of Turkish Criminal Code when the victim dies as a result of torment, and if it results with aggravated injury on account of its consequences, therefore we have to apply Article 87. Otherwise, the penalty of torment will award the offender a price. We have to apply all penalties of the crimes which committed by the offender to the victim periodically for preventing sentencing him to a lesser penalty. For this reason, we won't have to apply conceptual aggregation instead of gathering all penalties. If the practice does not accept to follow this way, therefore lawmaker has to make amendment to increase the amount of penalty of torment. For example, it can force the limits of penalty up like the crime of torture. By this way, judge can rule more fair penalties according to the features of concrete cases. Because of the systematical actions of the crime, which occur in different time courses, are the elements of the actus reus of torment, these actions legally concepted as a unique action, and there left no possibility to apply the provision of successive offenses here. Nevertheless, doctrine can know time breaks between actions, which shows the intention of the perpetrator has been renewed as the possibility of applying of successive offense provisions. But in the case there occur, but in these cases, there occur evidence problems. But if the offense has been committed against more than one person through a single act, then we can apply Article 43 by using second paragraph provisions. For example, leaving two people in a cold room for a while together, or slews them systematically will be appreciated in here. When we look at the practice of Supreme Court, we observe that court decides sexual assault and child molestation crimes different from torment crime, although they were the parts of torment during the stage. But it accepts sexual harassment offense within torment and decides only from torment crime. When we check the relation between treatment offense and torment in Turkish Criminal Code, Article 232, first paragraph, any person who ill-treats a person that they are living together within the same dwelling shall be sentenced to a penalty of imprisonment for a term of 2 months to 1 year. As you see, the provision offender and the victim of the offense are the same, are the ones who are sharing the same residence. But there is no similar limitation in torment crime. Ill-treatment can be defined as actions which conflict mercy, humanity, and compassion. These acts can show themselves as conflicting human dignity by giving physical or mental damages on victim. But for ill-treatment, there is no need to continuity and systematical appearance. For that reason, only one ill-treatment act towards the persons who are sharing the same residence will be sufficient to commit the crime. If the act appears as intentional wounding, therefore, the limits prescribed in Article 86, paragraph 2, shall not be exceeded. We can apply conceptual aggregation norms between ill-treatment and torment crimes here and punish the offender from torment crime only. But when we look at the decisions of the Supreme Court, we observe that High Court inquires continuity in actions for ill-treatment while adopting conceptual aggregation. If there is no continuity, it decides penalty only from intentional injury or related provisions. In the second paragraph of Article 232, any person who improperly uses the right to enforce discipline deriving from his right to educate a person who is under his control or for whom he is responsible for this person's growth, education, care, protection, or training of a profession or trade shall be sentenced to a penalty of imprisonment for a term up to 1 year. Here, the relation between the offender and the victim is specified. There is no requirement like this found in torment crime. The act has to show itself as ill-treatment of the right to care, grow, protect, and train the person who is under his responsibility. If it appears as intentional wounding, therefore the limit of this wounding must be in the level of simple medical examination. If it exceeds the level, then we have to apply intentional wounding provisions. If the X repeats in continuity, then we have to apply torment provisions for punishment. Last subject, sanctions and procedure. Although torment offense and torture offense are prescribed parallelly, when we compare them, we are facing with a great difference in penalties. In torture crime, the amount of penalty of simple form is 3 years to 12 years imprisonment, and in aggravated forms, the amount of imprisonment is increasing to 8 years to 15 years and 10 years to 15 years. And in Article 95, aggravated torture and the account of its consequences, it is possible to increase the punishment to lifelong imprisonment. On the other hand, the punishment of torment offense for a simple form is imprisonment of 2 years to 5 years, and for aggravated forms, it is imprisonment to 3 years to 8 years. I also want to emphasize here that there is no provision for the offense of aggravated torment and the account of its consequences. We are applying aggravated injury on account of its consequences. Norms Article 87 in these cases. Lawmaker of Turkish Republic preferred to punish torture serious than torment crime, depending on the position of the perpetrator. Although the actions and harms are similar, if the offender is public officer, the punishment will be higher, but it is not fair. We hope the punishment limits of torment moves near to torture in time, especially for uplims. Judicial investigation and prosecution stages for torment crime are same both for simple and aggravated forms. They are both prosecuted ipso facto automatically. Within the formation, public prosecutors are taking action and starting investigating procedures. I appreciate all of you for listening to me with patience. Thank you very much. I can answer if you have questions.
On behalf of everyone, I would like to thank you for this great and clear presentation.